Ladies and gentlemen, thank you for taking the time to be with us today, and welcome to the In-House Counsel Forum. This is our first webinar in this new inaugural program. My name is Samir Shah, and I'm an M&A partner in Khaitan & Company's corporate M&A group. A very warm welcome to this webinar to every one of you, whether you are in our audience in India or around the world. The In-House Counsel is an exciting new program from Khaitan & Company in 2023. This follows our very successful virtual programs in M&A that we have conducted over the last 2 years, the M&A Masters and the M&A Academy, both of which have proven to be immensely popular and have garnered a tremendous amount of support from clients and associates. In that same vein, the In-House Counsel Forum is designed to provide a private educational program and discussion forum tailored for in-house counsel teams in India. The program is structured to provide bespoke education, not only in substantive law, but also in management and other topics of interest to in-house counsel. The forum is private in the sense that the participation is by invitation only and not open to the public at large. We issue customized invitations by email to general counsels, chief legal officers, and senior in-house counsels at clients and close associates, and request them to extend these invitations to all members of their in-house teams. We hope through this process to provide continuing legal education to in-house teams, like I said, on matters of interest for them as well as their companies. The format of today's session will begin with a formal presentation, and we hope that the session will be interactive, and we invite you to ask questions during the webinar as issues arise. We have already received several audience questions. If you have a question, please submit it using the facility provided in the webinar portal. If we cannot cover all questions during the webinar today, we will of course respond offline by email after the webinar. Also, a copy of the presentation and certain summary notes of the presentation will be sent to you after the webinar as well. So to introduce today's presentation, the topic is anti-competitive business practices. The topic is immensely important for the business community and in-house counsels for many reasons, some of which are: A, competition and antitrust regulation in India is increasingly becoming more and more onerous. Our regulator is becoming increasingly active and aggressive in the pursuit of transgressors. Very substantial penalties await those people who are found to be non-compliant, and there are serious implications for the concerned individuals as well, and not just the organizations. For these reasons, we thought this would be a great place for us to start the in-house counsel forum, and as well as the fact that in our survey of in-house counsel conducted last year, this topic was felt to be of great interest to many in-house counsels. So to introduce our speaker today is my partner Anisha Chand. She is a competition partner based out of our Mumbai office, although she works and advises clients nationally and internationally. Anisha has more than a decade of experience, and she is highly experienced in this work. She recently represented Inox India in the abuse of dominance proceedings before the CCI, as well as Glencore Agri Products in the recent Lentils cartels case. She is also presently advising several leading cement companies in cartel allegations before the CCI. Therefore, it is difficult to think of a better partner to share her knowledge with you on this topic. So I now invite Anisha to deliver her presentation. Over to you, Anisha.
Thanks, Samir. Thanks for the very crisp introduction, and a very good afternoon to all the lovely audience who's taken the time to attend this seminar today. So very quickly taking you through the agenda that we have. First is obviously the introduction to the competition law, what that entails, what is the purpose of competition law, how that impacts your business. Second, again, no-brainer, why should you be compliant with this law? So we're going to discuss very quickly what are the deterrence measures that we have under the statute, what is the enforcement mechanisms, what are the kind of agreements, and what do you mean by abuse of dominance? And of course, all of this is going to be backed by a lot of illustrations. And the last 2 points are the most critical ones, which is what is upcoming, what do we see on the horizon, again, why should you be aware, and how does that impact your business, and what are really the key takeaways. So with that, we're going to start off. Next slide, please. So yes, so what is competition law? Competition law in a nutshell, if I have to tell you, is very simply it prohibits practices that harm free and fair competition in the hope that this will lead to newer, improved and cheaper products. And who can harm competition? That's the obvious next question. So any dominant entity which imposes any sort of unfair terms and conditions in its agreements with its customers, suppliers or intermediaries, or any rival firms who join forces to say increase prices, they can harm competition. And who will suffer as a result of this? Everybody across the value chain. So your competitors, suppliers, customers, and even end consumers will suffer if your market practices are distorted and they distort competition in the market. And then therefore, how does competition law help? It helps by checking these practices that can lead to this kind of harm, and by providing sort of reduced prices, improved quality, innovation, and greater information asymmetry. So this is really the purpose of the law. And which brings me to the next question, that what are the kind of sanctions or penalties that are mentioned in this law? Now, a question that we get often asked is, we shouldn't be worrying about this law at all because, there is no jail term, there is no imprisonment. Well, yes, there is no jail term in this act, and at least, so far as India is concerned, for competition law breaches, you may not go to the jail, but for other jurisdictions like the US, like the EU, China, there are imprisonment provisions. So if you're a multinational company, you have to be careful that it's not just an infringement in India, it could also expose to infringements in other jurisdictions. But that aside, if you look at the Indian Act itself, the financial penalties can be as high up to 10% of the average turnover of the preceding 3 years for non-cartel offenses. And for cartel offenses, which is essentially collusion between rival entities, it could be up to 3 times of the profits or 10% of the turnover of each year in which the cartel was subsistent. So whichever is higher, your penalty exposure is that. Penalties, of course, on theory look very high, but in reality, is this even close to what we are talking about? Yes, these are not theoretical numbers. In the last 13 years, you can see up on the slide, the CCI has imposed headline grabbing penalties, which have totaled up to USD 1.8 million, which is a little over 15,000 crores in Indian rupees. Right, and of course, I'm sure everybody has heard about the cement cartel case. There was a penalty of more than 6,300 crores that was imposed on cement manufacturers for price fixing in the cement sector. Right. More recently, Google has also suffered a penalty of over 2,000 crores in India. So these are all real numbers. Individuals are also not completely insulated. There could be proceedings against individual directors, promoters, key managerial persons, and they can be penalized if they are responsible either directly or vicariously for the anti-competitive conduct in question. They can be penalized up to 10% of the average income for the last preceding 3 years. And again, once again, these are also real figures. There are a number of individuals who have been penalized. There's been a penalty of 4 crores that was imposed on a gentleman in one of the pharmacy cases that the CCI dealt with. So you can see that the CCI has highly intrusive powers, and it is a regulator that can impose the highest economic penalties so far as India is concerned. Moving on with that.
So
that
Anisha,
brings us to
you have scared our audience, and I can see there are multiple questions on just the penalties on individuals. Are there any steps that can be taken to protect directors, senior executives against individual penalties?
Sure. So I think that's a very obvious answer. You need to, one, your entity in question, the business needs to be compliant with competition law. And second is that you can take certain measures to ring fence the director's liability. So for instance, if you have done a due diligence on certain key managerial persons that you have hired for a particular business that is seen to be in infringement, you should try and say that, look, we did all the due diligence. There was no reason to believe that this person had any ability or did not have knowledge of competition law. We have given a number of trainings to our individuals. So whatever we could possibly have done, we have an annual compliance program and stuff like that. So we have taken all the measures that we could have, right? But yet this employee has gone and done certain XYZ activity, which is found to be in breach of competition law. So if you can establish bona fides, if you can establish that you've taken all the pains and all reasonable action, and you had no reason to believe that this conduct could land the company in trouble, you should, we think, should have a solid defense before the CCI. I hope that answers the question.
Great.
So if I may just move on, I'll take you through the overview of the competition law. So there are two substantive provisions when we talk about anti-competitive conduct. These provisions came into force in 2009. So the first limb is section 3, which is anti-competitive agreements, which includes horizontal agreements, which is essentially agreements between rival entities, and vertical agreements, which is agreements with anybody else who's not your competitor. Right? And what anti-competitive agreements state, the definition is really any agreement with any entity which results in appreciable adverse effect on competition is void under law or could be voidable. So there are certain categories which I'm going to discuss in the next slides, which you should be careful about. But the second important limb is the abuse of dominant position, which is again a provision that is getting very, very actively used in the context of tech sector investigations. There are several ingredients of which we will discuss, but these are the two limbs that essentially we are going to be discussing today. So to explain to you, next slide please, what anti-competitive agreements mean. First of all, I think we need to understand that agreements is not a formal agreement which is written or which is enforceable under law. So it's not a traditional formal agreement. An agreement for competition law could mean any sort of arrangement, understanding, whether it is tacit or implied. Even a nod or a wink can tantamount to an agreement. And the standard of proof, so this doesn't have to be, like I said, direct agreement. The CCI will prove, or the Competition Commission of India will prove an agreement based on a number of circumstantial facts. And the burden of proof, therefore, that is, or the evidentiary standard that is used is preponderance of probabilities, which is a threshold that is much lower than the threshold of beyond reasonable doubt, which is what we used in criminal law. So this is important to understand. And for vertical agreements, so this is for generally anti-competitive agreements, this is one thing that's very important. The second, so now the two aspects, your agreements which are horizontal in nature are agreements between competitors. So if you're fixing prices with a competitor, it's a horizontal agreement. Vertical agreements will be any agreement between your suppliers, customers, or even intermediaries. Two important things to note is that even if you have a competitor collaboration, which is essentially a horizontal agreement, but with enhances certain efficiencies. Case in point, if you look at what happened in COVID, we saw a number of pharmaceutical companies joining forces to come up with a vaccine. That is perfectly legit. Similarly, if there is any sort of restrictions that you have in your agreements, which is pursuant to certain legit restrictions allowed in the respective IPR laws, that could also safe harbor you and insulate you and totally ring fence you from any sort of liability under competition. But again, this is not absolute, and this is also quite a subjective assessment. So with that, I'm going to take you through
so
the
if I can,
just
on agreements, there seems to be a question, and this is more in the context of horizontal agreements. What if there is similarity in prices due to mere coincidence or algorithms? How do you prevent the CCI from viewing these instances as agreements?
So now that's a very topical question. Algorithmic pricing is becoming more of a norm, especially because of increased price transparency that we are viewing in the world. Everything is available on a Google search, and now we have ChatGPT and the bards and all of that. So there is increased price transparency, and what's happening is that everybody is running algorithms at the back end. So if there is pure coincidental similarity in pricing, as long as you can show that this is purely coincidental and it's not driven by concerted action, it's an independent action, and and you have not built the algorithms in a manner that they talk to each other and share information, you should be fine. We've had a case in the airlines industry, and we represented some of them, and they got acquitted even though there was similarity in pricing, because we could establish that it is just purely coincidental, and we've taken measures. All the inputs that go into building the algorithm are completely different, and the mechanism by which the prices are arrived at are different. So I think that helps, and that answers the question. So moving on to the second limb of how we do the assessment, what is appreciable adverse effect on competition? As you can see, we have two text boxes here. This is a balancing act, and by inserting appreciable, we mean that if any sort of de minimis effects by virtue of your agreement, even if they're adverse, shouldn't fall foul of the law. There needs to be a significant adverse effect or appreciable adverse effect on competition. So the CCI also does a balancing act. On the left side, you see anti-competitive effects of the nature of, so if your agreements are creating any barriers to entry, if it is driving existing competitors out of the market, it's creating any sort of foreclosure on competition, has to be balanced by any sort of pro-competitive effect. So if there is, in the example that I gave you about pharma companies collaborating together, the accrual of benefits to consumer for coming up with a COVID vaccine that is effective, that works, was much, the benefits of that much significantly outweighed any sort of anti-competitive effects of that collaboration, and therefore this is not problematic. Similarly, if your arrangement is creating any improvements in production or distribution, or it is promoting some sort of technical and scientific economic development, and probably, those sort of arrangements, even if there is some sort of adverse effect, are not going to be problematic. Right, so that's the theory behind what kind of, so this is a balancing act essentially that the CCI needs to do to see whether you're in trouble or you're not. Next slide, please. So segueing to what horizontal agreements are, we just discussed it. Any agreements between competitors is a horizontal agreement. Cartels are the most pernicious of them all, and we need to understand that these sort of agreements, which are in the nature of cartels, could include price fixing agreements, agreements to limit or control the production, supply, share markets, share customers, rig bids. And price fixing agreement doesn't mean that I need to fix the price to the decimal point. That is not the standard. Similarly, if I'm entering into an agreement to control supplies, it doesn't mean that I'm going to reduce my production by the same quantum. So there are ways and means in which this is supposed to be deciphered. But what's again important is that if there is any sort of discussion on any of these four categories between competitors, there is a presumption in law that this is going to create an appreciable adverse effect on competition, and the burden on proof is really on the parties to submit that this is not creating that easy, right? So there is also something that we call the but-for test that is used increasingly by the CCI, since most of these sort of agreements are hatched in a clandestine manner, in a secretive manner. So therefore, CCI needs to rely upon a lot of circumstantial evidence. So there is a but-for test that we use, that apart from there being a collusion, the behavior in the market cannot be explained by any other alternative rational reasoning, and therefore this is sort of preponderance of probabilities in favor of there being a cartel. So let's look at some practical case studies with that theory in mind. So this is the interesting beer cartel case. These are all very recent, and you can see that we've picked up cases in diverse sectors. So what happened here, this was a suo motu investigation by the CCI. That means that they voluntarily sort of started it. But full disclosure, there was also leniency application by this entity called AB and BEF. And leniency is essentially a whistleblowing sort of an application that you make to the CCI in exchange of clemency. So what AB and BEF did is it disclosed that AB and BEF and two other entities, United Breweries and Carlsberg, they used the All India Brewers Association as a platform to align beer prices and also make certain representations to various different state governments, which state government organized corporations. So as you know, alcohol is a state subject, so all states get to make their own policy. And these state corporations were interested with controlling the supply of liquor in the states. Many states were involved, such as Andhra Pradesh, Karnataka, Maharashtra. But what happened here was, pursuant to the leniency application, there were dawn raids that were conducted at the premises of each of these manufacturers and the association. And the investigation revealed that there were multiple instances of sharing of sensitive price information, revenue stock, sales data, and there was a clear intention of limiting the supply of beer in certain states. What was interestingly argued, and this is important, by some of the entities was that the request ultimately for making those price adjustments were rejected by the government. So there was no implementation, and therefore there should not be a cartel. But the CCI said, sorry, since price division quotations were submitted to the government pursuant to an agreement that you all had, the implementation is completely moot and the threshold for a cartel is already established. Another interesting dimension, which I must mention, is that some entities had also an understanding that we'll fix the procurement price for buying back the second-hand used bottles. This was also considered. Ultimately, because there was a leniency by AB and Bev, it got 100% waiver of penalty. UBL, which is United Breweries and Carlsberg, were fined to the tune of 750 crores and to 120 crores respectively. The second case is in the case of it was a maritime transport cartel where again leniency applications were filed by certain car shipping companies. What they revealed was there was a collusion by way of a very creative respect rule where each carrier was able to maintain their established position with their customer accounts, and these customer accounts were essentially automobile manufacturing companies / OEMs. So through this mechanism, the carriers could maintain or increase prices by acting in concert with the other carriers, and also enabled them, this sort of rule enabled them to jointly resist any sort of request for price reductions by such OEMs. So each carrier essentially had an understanding that they would respect each other's trade route and incumbency status with each OEM, and they would not try and competitively outbid them to get the relevant customer accounts for which they had an incumbency status. Very interesting case. There was a penalty that was imposed. Aggregate penalty that was imposed was 63 crores roughly on K-Line, Mitsui, Nissan. The leniency applicant was the first one, which was NYK. With that, this is an interesting bid rigging case in Rajasthan cylinders. There was a penalty that CISA imposed on 45 LPG cylinders. There was recurring bidding in this particular case. There were just limited number of buyers, so the buyers were obvious. There was Indian Oil, there was Hindustan Petroleum, and Bharat Petroleum. So there were limited number of sort of customers in this particular case, and many suppliers. And there was identical sort of bidding pricing despite varying cost structures of each of these manufacturers. So this CISA relied on a number of things, that there are fewer entrants, there's a very active trade association. There were also common agents to hold that, look, this is definitely a collusion activity. There is no other explanation. It's another matter that this went to the Supreme Court and said that because there are limited number of buyers and everybody is catering to these three identified buyers, they have the countervailing buying power to actually influence the prices at which they are getting cylinders sold. So this does not satisfy the alleged but-for test that the CISA has used, but there is a clear alternative explanation based on the structure of the market, and all of these guys were acquitted. So these are our case studies. Moving on to vertical agreements, which are your agreements between customers, suppliers, and other intermediaries. So as opposed to horizontal agreements.
Before that, just on Dawn raids, Anisha, there seems to be at least 3-4 different questions on Dawn raids. But just to try and summarize all of them, somebody's asking something, somebody's asking something else. Are there any do's and don'ts across the board on an agnostic basis that you recommend for people to be prepared for Dawn raids?
Sure. So dawn raids is again very topical, interesting question. Dawn raids are search and seizure operations, as some of you would know since you're asking the question. So once the dawn raid happens, number one rule is you have to look at the warrant, because without the warrant, they can't raid your premises. Number two is you have to cooperate. They are your authorities, so you can't antagonize them or try and be non-cooperative, because they have the powers to even penalize you for that sort of non-cooperation. Third is try and call your lawyers immediately. You should have a hotline number. You should know that the minute there's a raid, you need to call your lawyers. Third would be maybe, give them all the right answers, but don't volunteer extra information. Fifth, perhaps, would be to take a record of everything that has happened during the raid. So you should have a proper debrief session. You should know who the investigating officers have spoken to, what are the kind of questions they've asked, what is the kind of material they are seizing, and try and figure out what is their area of interest or the issue of violation that you're looking at, and then prepare a debrief, contact your lawyers, and take action immediately. Please do not report anything to the media until you've taken all of these measures.
Fantastic. I can see you have a slide on anti-competitive agreements. There are a few different questions in different sectors. I'll wait for you to finish this slide and then come back to that.
Sure. Okay. So we've got, so this is a list of illustrative sort of arrangements that we typically see. You can see tie-in arrangements, exclusive supply arrangement, exclusive distribution, refusal to deal, resale, price maintenance. Now, what's important is, and how I contrast this from a horizontal agreement, is that in a vertical agreement, there is no presumption of an AEC. There is inherent recognition in the law that there are pro-competitive benefits of having certain restrictions in your agreements with suppliers and customers. So therefore, we have the rule of reason test. And by and large, if the market share of the entities which are entering into this agreement, they have a low market share or they have low market power, then these are necessarily not problematic. But again, every sector works differently. So you may think that you have a smaller market share, but in the larger scheme of events, everybody has smaller market shares and you look larger in it. So you could be in trouble, or at least you need to review your agreements in that line. Right, so I'll just give you an example of the kind of pro-competitive effects that I'm talking about. So in an exclusive distribution, which is fairly common, what happens is that if I'm a FMCG manufacturer or if I'm a automobile manufacturer, I have exclusive distribution agreements with my dealer. So I will say, okay, you focus in South Bombay, the other guy focuses on Navi Mumbai, or the suburban parts of Mumbai. So what happens is, as a consumer, I don't have too many options. If I'm living in Kulava in South Bombay, I will only go to the distributor who's in South Bombay. So what it does is that there is reduced intra-brand competition because I have only one person to go to. I don't have an alternative, right? But from the manufacturer's perspective, it allows me better management and supervision of my distribution channels. It also incentivizes the exclusive dealer to invest properly because it knows that it has some sort of exclusivity in this territory. So there are, again, it's a balancing act. The list is non-exhaustive. With the advent of digital players and intermediaries, this cannot be an exhaustive list, and we have seen that in some of the cases. But Samir, do you want to ask me any questions now, or should I move on?
So, Supa, you covered automotive. One of the focus questions was on the automotive sector. There's another one more in the context of healthcare. And so this says that if doctors are engaged on a consultancy basis and not allowed and on an exclusive basis, how would that be viewed? And they've clarified these are doctors who are niche in that treatment line and perhaps the only doctors rendering such services, etc.
Look, healthcare, it's a very interesting question. I can give you some broad guiding principles. If the doctor, so the doctor is a market in itself because he's the only one who's supplying that sort of expertise for, let's say, open heart cardiac surgery. Let's hypothetically take that example. So there would be a limited pool of doctors who can provide that. And if you have exclusivity, personally, I feel that it's obviously creating an entry barrier. It is also at a public interest level. It's not something that you should be doing because that limits the ability of that doctor to reach out to other sort of states or other hospitals and give the same sort of treatment. So I feel that from a medical practitioner's perspective, also entering into an exclusivity could be unethical and also in violation of the oath that they take. But no, this could have challenges even under competition law, is what I would say.
Right, and there's a question from defense, slightly different, but they're saying that today defense contracts are assigned on a nomination basis to specific companies based on turnover capacity or proximity to the end user. Does this mean there are unfair competition barriers being created in the market?
No, so I'll answer this question differently. Any sort of eligibility criteria, and that's what I think these terms are, which are based on an objective justification, which are reasonable, and are also qualitative in nature. You can't really say that those are problematic because there is a filter that has been applied. And therefore, by definition, I am getting knocked out from bidding for that sort of a tender, right? So whatever metrics have been cited here, to me, prima facie, I don't think they are problematic. Can they be challenged? Anything can be challenged. Anybody can go to court. Will it stand the scrutiny or test? Probably not, because based on whatever I've heard in the questionnaire itself, as a lawyer, I feel that I can defend this to be an objective qualitative criteria without having any intention to exclude. The minute you have an eligibility criteria which is fair, reasonable, backed by clear rationale, normally those are not seen to be problematic.
Right. Last one. So we did automotive, we did healthcare, we did defense. We have something from EPC. So fixing the amount of discount that can be offered by an exclusive dealer, will that be seen as anti-competitive?
Potentially, if you have the market part, if you're fixing the price, that means you're fixing the minimum price at which he can resell. You're controlling his pricing. So that's actually the fifth bullet on this slide. It's resale price maintenance. You get to fix the price at which you sell to him. It's a principal to principal agreement. You should not be telling him at what price he should be selling at. You're taking control of the market. You're interfering too much. And you could be in breach of the law. You can give broad recommendations or soft recommendations that, probably try to price around this, but please don't enforce it. You could be in trouble. And I'm going to take the liberty of, giving an explanation through an illustration that we have on resale price maintenance. So we've got a case in the automobile space. We've got Maruti Suzuki. What happened here? Let's see. So Maruti Suzuki had a very interesting discount control mechanism wherein the dealers were told not to offer discounts beyond what was pre-decided and pre-approved by Maruti, and if they had to go beyond that, they had to get prior permission. So to ensure that this policy was being followed, there was some sort of monitoring agency that was appointed by Maruti. And what was done is that if there was any sort of violation or deviation from this policy, there was a monetary penalty that was imposed. And there was also a threat that Maruti will suspend supplies of certain fast-selling premium models. CSI said this is problematic. You're Maruti, you have a 40% market share. Obviously, you have market power. And what you're doing by controlling the maximum discount is actually fixing the minimum price of resale, which is a clear breach of the law. You are also reducing intra-brand competition. Maruti dealer, that competition is getting killed. You're softening competition because you're setting the price for everyone. You're by setting the maximum discounts. And because you're Maruti, this restriction on your pricing strategy will mean that the inter-brand, so between your Hyundai, Maruti, or Volkswagen perhaps, the inter-brand competition will also be impacted negatively. For that reason, Maruti suffered a penalty of 200 crores. This matter is an appeal before NCLT, National Company Law Appellate Tribunal. Next case in the digital tech space, one of my favorites. Also, I advised one of the clients on this matter. It's a very interesting case. Make My Trip, Go Ibibo. We all are familiar. It's a very popular online travel agency. And Oyo, again very popular, no introductions needed. They had an agreement by way of which Oyo imposed a restriction on Make My Trip to say that, look, you have to delist Fab Hotels and Tribo from MMT's platforms. These were obviously rival franchisee chains of Oyo, which is why they asked for the delisting. And there was a little bit of a quid pro quo because Oyo agreed that I will not list myself, or Oyo Hotels will not be listed on other OTAs or online travel agencies during certain peak seasons. So there was a mutually beneficial arrangement that they had. Now it's very important that for small franchisee chains or hotel chains like Fab Hotels and Tribo, for better visibility, discoverability, access to end consumers, you need a platform which is as big as Make My Trip. And what the CCI said was exactly this. They said that there is clear appreciable adverse effect on competition. There is adverse impact of the delisting on Tribo, Fab Hotels and their hotel partners. There is high level of dependency that any of these brands have on somebody like a Make My Trip. And there was a clear artificial advantage that was being created for Oyo because of this entire delisting. Penalties were imposed. Make My Trip was suffered a penalty of 224 crores roughly, and Oyo separately was penalized to the tune of 170 crores. So all real penalties. These two cases are in appeal, but interesting cases to take note of. With that, I'm going to segue into the last substantial limb of this presentation. This is on abuse of dominance. Number one rule is dominant position is not frowned upon under the law. You can have a 90% market share. If your conduct is kosher on the market, you should be fine, no problem at all. There is but a special responsibility on an enterprise who's dominant in any product or geographic market to be a little more careful about its conduct in its agreements. Abuse is what is problematic. So to identify whether there is any problem of your business in the context of abuse of dominance, there is a three-step process. One is what is the relevant market, very crucial to see what your market share, whether you're dominant or not. The assessment of dominance itself, there is no magic market share number which determines whether you're dominant, but the definition of dominance is the ability to act independent of market forces or the ability to influence the market in one's favor. So again, once again, you could be a 90% market shareholder, but there could be other ways in which you have a active regulator, you have very high countervailing power. So even though you are 90%, you don't have the ability to act independent of market forces. So you wouldn't even be dominant. And the third ingredient is assessment of the impugned conduct, whether that amounts to an abuse. So to see dominance, there are a number of factors. Market share is just one of the many factors. In this presentation, I'm not going to go too much into it, but if you have a durable high market share, you could have a problem. You could be seen as dominant. If there is high dependence of consumers on you, if you have your size, resources, economic power of the enterprise in question is very, very high, then you could be seen to be dominant. If they're fluctuating market shares, probably not, because that shows you're operating in a competitive market and your fluctuations in market share are actually representative that you don't have that kind of market power, right? So next slide, please. So I'm going to very briefly explain to you what is the concept of relevant market, because that's critical to see whether you're dominant or not. So it has two components. One is product market, the other is geographic market. Both are very important. Product market is based on what is the degree of substitutability or interchangeability between the products in question. It is determined based on physical characteristics, end use, price, consumer preference, and a host of other things. Geographic market is equally important to define properly. So if geographic market is where the conditions of supply of service, supply of product or service is homogeneous, that's your product market or catchment area. That is also determined by what are the regulatory trade barriers, any sort of local specification requirements, any specific procurement policies, distribution facilities and their role, etc. So for, since we're talking about cars so much, a car could be a single product market because functionally it is taking you from point A to B, but each category of car, whether it's hatchback, sedans, SUVs, based on the physical characteristics, price points, etc., they could be different. To give you an example of a geographic market, for competition, for geographic market in terms of sale of smartphones, it could be the entire country, but for a food delivery service, cinema, theater, it could be just citywide or probably smaller. Right? Some of the case studies to just understand this concept a little better. Move on to the next slide, please. Is the first case, which is in the healthcare space. In this particular case, in the Saudi case, what the CSAS said is that there is a difference and there's a distinction between a sleeping MRI machine and a standing MRI machines, and there were multiple factors that they considered. First was that a standing MRI machine is more effective and provides more accurate diagnosis for certain types of ailments, and it is more accurate for specific portions of the body, right? As compared to conventional MRI machine, where the whole body can be scanned, but for a standing MRI machine, it is meant specifically for certain joints and spines. So there were other aspects also, but this is the nuance at which the CCI looks at a market definition. To illustrate a case in the context of a geographic market delineation, I'd like to discuss the DLF case very briefly. In this case, the CCI considered that a decision to purchase a high-end apartment in Gurgaon was not substitutable with a decision to purchase a similar apartment in another geographic location. So what it considered the unique geographical characteristics of Gurgaon, the importance of the geographical location when buying residential property, to conclude that the market cannot be in any way bigger than Gurgaon. And importantly, what it also discussed and analyzed was that even if there's a little bit of a price increase in Gurgaon apartments, that increase in price is not going to deter or change the decision of the person to shift their residence to any neighboring city or location. So moving on to the third ingredient of abuse of dominance is what constitutes abuse.
So before that, maybe we pick up one question, and this is something we got in registration from one of our clients who's in the capital goods, defense and automotive space. And their question was, other than sales turnover, how do we compute the dominant position of an enterprise in a relevant product market?
Okay. So I'm not going to answer specifically in the context of defense, but there could be many parameters. Turnover is actually the reason why we are talking about Digital Competition Act, is because turnover no longer is representative of the market power that a company has. It's based on your growth, your number of users, and multitude of other factors. But if it's not turnover, it could be, so defense is largely a tendering business, right? So there is something, there's an analysis of the winning and the losing tenders that we do in a bidding sort of an industry, where we look at for a period of 10-15 years, what all bids have you participated in, and how many of those bids you have won. So that's calculation of your probability of winning. So if you say 1 out of 15, you have won more than 10, that means that you are on a winning spree, which makes you one of the top competitors in the market. And this has got nothing to do with your revenue at all. So there could be various metrics determined based on the market in which you're operating. And for a tender market, bidding sort of analysis becomes very important. And then you can also see who's the next biggest competitor. So somebody else who's won 8 out of 15 could be your second closest competitor, right? So it really varies industry to industry. There is no one answer. Revenue is one of the many thresholds that is used. Okay, so abuse of dominant position, as you can see, there could be two types: exclusionary, exploitative. Exclusionary by definition means that you're denying some sort of access to somebody. It could be through your exclusivity, non-compete sort of arrangements. It could be through predatory pricing, by pricing so low that you want to eliminate competition. It could also be exploitative in nature, which is, again, it can take various forms. These are all illustrative only, but anything that is unfair, discriminatory condition. We'll talk about some case studies, so this concept is a little clear for you. And actually, we'll just hop on to the case study. So we'll speak about very recent case, the abuse of dominance. Google was penalized in 2 consecutive orders. One was for the Android policies on the Android OS operating systems in relation to smartphones. So what was alleged in this order was that Google had entered into multiple one-sided agreements with OEMs. So your phone manufacturers, so your Xiaomi's, Samsung, Oppo's of the world. So those were the OEMs who were not really considered, but I'm just giving an example of who these OEMs are. So there were multiple agreements where there was a requirement to mandatorily pre-install Google's proprietary app system. So your YouTube, your Google Maps, Google Pay, etc. So all of these things led to denial of market access to rival applications. And these agreements also prohibited the ability of the OEMs to further innovate and develop devices operating on alternate versions of Androids, which we sometimes call Android forks, right? Google was also deciding the placement of its apps, its search engines, and a variety of things to see that it gets a special advantage when the phone comes into the hand of the consumer. There were multiple other agreements. There were also sort of prohibitions to not use third-party applications. There was also sort of another connected case with Google billing system that probably I'll touch upon a little brief in a bit. But what the CCI said is Google was dominant in Android operating software, Google Play Store, general web search, and a bunch of other things. And it ultimately concluded that all of these agreements were actually perpetuating and creating more and more entry barriers. They were creating that sort of foreclosure on the market. it was limiting end user choice, and clearly was an abuse of dominant position. Apart from a monetary penalty that was imposed of around 930 crores, there were a lot of remedial measures that were imposed on Google. We've heard about that. Supreme Court has also said, please go ahead and change your business policies. But what were these? Let's discuss some of these. So the measures that were imposed on Google was that the OEMs need to be free to elect the proprietary apps that they want to pre-install. So if they want to pick up only YouTube, they should be allowed to pick up only YouTube. The entire suite of Google services or apps should not be compulsorily or mandatorily required to be provided. OEM should be allowed to come up with certain Google Android forks, which are any sort of innovations on the Android operating system. Google should not enter into any sort of arrangement with OEMs for ensuring any exclusivity of its search services. So there could be a Google search icon, but you should also be allowed to have a Safari or Microsoft Bing, etc. And all the users should be allowed to pre-install any apps, any of the Google apps that are pre-installed. So this is the case, and the Play Store policy case, the Google Play billing case, which I'm not going to discuss in detail, but this is another interesting case where there was a mandatory usage of Google Play's billing system for third-party apps. And the processing fee that Google was apparently charging from app developers was also disproportionate, unfair, and discriminatory. And here also there was a penalty that was imposed in addition to certain other remedial measures that Google had to undertake to sort of not impose these kind of restrictions on app developers to use the third-party billing system, etc. Another case, which is in a more traditional sector, is the Grasim case. So this was in the context
before we
of,
go there, I think particularly on Google, there were at least 3 or 4 different questions. I'll just pick one of those. Maybe you've already addressed it, but still just to re-emphasize. Google provides a majority of its products to consumers and even OEMs for free. How can this be considered anti-competitive?
So I think the dust has quite settled on this one. And I'm going to quote the social dilemma here, which is if you're getting some service for free, that means you are the product, right? So this is exactly what happens in not just Google, but generally any services that you're getting for free. There are no free lunches. And here it's very clear that even though your search services and etc. are free of cost, Google is actually using all of that data to monetize it for advertisements, etc. So this is a commercial activity and therefore very well falls within the ambit of the competition law. So Grasim order, very quickly. This was in the context of viscose staple fiber. In India, Grasim is the only entity which produces, or maybe the only relevant substantial entity which provides or produces viscose staple fiber. It's cotton-like, not cotton, and used in a lot of used a lot in the apparel industry. So here what happened was that dominance was established because it was probably the only relevant player in India. And what Grasim was doing was that it was selling this VSF to different consumers at different base rates. So the base rates were different without any rationale. There were differential discounts provided to each of the customer, which again, in and of itself may not be problematic, but the way this was done was problematic. The communication of the prices were done confidentially to each local customer, but there was also an overreach by Grasim because they were seeking details of production exports from Indian spinners who were the customers of Grasim for the sale of VSF. So they would want to know whether you're exporting this, whether you're using it internally, what are your target, what's your target audience, what's the industry that you're supplying to. And the CCI said that this is onerous, it is unrelated, you shouldn't be asking this kind of information. It is highly invasive and it is a manifestation of abuse of power by Grasim. So the CCI imposed a penalty of a little over 300 crores on Grasim. Grasim has also appealed this order, and we'll see how this case pans out. So that brings us to the last segment of our presentation, which is very interesting again. What is on the horizon? As you would see that we are witnessing an explosion of reforms in India so far as competition law is concerned. We have a competition amendment bill live sitting before the ongoing budget session that we have, and there are a number of changes. But what you need to know is that there is going to be the CCI has blessings of the government. There is likely to be stricter enforcement of the law, both in letter and spirit. The exposure, the slide that we talked about compliance and why you should be complying, because the exposure to your penalty exposure is based on your total turnover. Now that total turnover has been clarified to include global turnover. What all of us lawyers have been arguing, and to an extent it was also accepted by the Supreme Court, is that the exposure of penalty should be limited to the relevant turnover, which is relevant and limited to the infringing business. So if I'm a multi-product company and in one product area, let's say pharmaceutical, there was some sort of cartelization, so only the revenue attributable to the pharma division should be taken into consideration and not the turnover of the entire company. But now there is going to be clarity that it's the full turnover that I'm going to consider. It's not restricted to that. However, there is also expectation that some sort of penalty guidelines will come, and that will, probably lower the overall impact. But at least the statute probably is going to say that it's going to be the global turnover that I'm going to use as base to predicate my penalty computations on. Second point, some people have already asked this question. We have seen 4 dawn raids in the last 1 year in different sectors. There's alcohol, there is steel, there is cement, and in the last 3 years, I think there have been at least 8 to 9 dawn raids that we have seen. We are seeing very well coordinated dawn raids, multi-city dawn raids, very sophisticated set of investigators who come with a team of forensics, cops, etc. So, get your house in order before the CCI comes knocking, and please do all of those things that I mentioned right in the middle of the presentations on your do's and don'ts. Third is there is higher interagency dialogue internationally and domestically, which means that there could be higher risk of discovery of unlawful conduct. The Enforcement Directorate has been given a clear direction by the Ministry of Corporate Affairs that any relevant information that you see that may have a CCI angle, please let the CCI know. So that's another thing to keep in mind. Digital Competition Act is in the making, as some of you would know. Systematic intermediaries of digital importance, which are cities, have to watch out for higher compliance. I'm not going to deep dive into this, but if you're in the tech space, if you're acting as a gateway, if you have a huge user base, you have a good market capitalization, this is a law that you should watch out for. It could make compliance a little tougher. Last bullet is, increasingly we are seeing that constitutional courts and appeal forums are reluctant to interfere with any CCI decision. Earlier it was easy to go to a writ court and say CCI has not followed due process, so you please stop the investigation. Less and less of that is happening, which means you have to fight your case on merits. Last slide, key takeaways from this presentation. Most important bit, I would say, as any other lawyer would say, it's very important to identify your risks and identify your pool of risky employees. What do I mean by that? If you're in an industry which is concentrated, it has an active trade association, if you're participating in a lot of tenders, if you have really long-term exclusivity contracts, identify whether your business has any of these competition risks. If you have employees who are in procurement, sales, marketing, please be careful. Do a risk assessment. Please train them through policies, code of conduct, regular trainings. You should have an internal probably hotline where any sort of unlawful conduct which can breach competition law is flagged immediately to you. You could also have mock dawn raid trainings to prepare people on what to expect if the CCI does knock your door and come up to do a search and seizure operations. Commitment to comply always has to come from top down. I think the directors have direct stake in this entire thing. This needs to be high priority on the agenda item, because we discussed that directors are also liable. It could be vicarious liability, it could be direct liability because you had knowledge or you were responsible for the infringing conduct. So this is an important item that needs to be in the top list for you to worry about and comply with the law. With that, I'm going to hand over back to Sameer. Thank you so much for a patient hearing and for all the interesting questions that I really liked answering. It kept me on my toes and kept me thinking. So thank you very much for those questions.
Thank you very much, Anisha. And we must thank our audience. We've had attendees from diverse sectors, and there are several questions we've not been able to pick up. So, for example, we've had questions from Tata Technologies, Dell, Bharat Forge, Larsen & Toubro, IHH, Bechtel, KPMG, and several others. I could go on and on and on. So thank you very much to our audience for participating so enthusiastically. We are, of course, conscious of time. Whatever questions we could not address while Anisha was speaking, we will follow up over email. But before closing, I would like to ask each of you to respond to the poll. This should be on your screen any moment now. This is very quick feedback on today's webinar, and it really helps us in our continuous improvement program. So again, many thanks to everyone who participated in the poll. And finally, I would like to thank Anisha, whose presentation was outstanding, and also really to our audience for the attention and the participation. And we do hope that you found this webinar very interesting and certainly enjoyed bringing it to you, a worthwhile investment of our time, we'd like to believe. After the webinar, as I mentioned, we will send you a copy of the presentation, the materials, and some of the summary notes. And you will also separately receive a request for feedback on the webinar. It's a very short survey. It takes less than a minute to complete. And if you're interested in in-house training or on any other matters arising from this webinar, please do not hesitate to contact us. Our contact information is on the slide in front of you. And thank you once again for your attendance today. And we look forward to being with you again through the journey of the In-House Counsel Forum. Thank you very much, ladies and gentlemen.